may be seated.
Yes, Judge.
Yes, Your Honor.
Fine. Closing argument. Okay.
Thank you, Judge. Good morning, ladies and gentlemen.
Morning.
Morning.
Before I begin any remarks, I just been doing this probably longer than I want to admit. I can tell you this, that the attention that you have shown and the respect that you have shown, not only myself, but Mr. Muntean and the court, is very much appreciated. That being said, the government's role in prosecuting a case is to quite simply get convictions. That's undisputed. They want a conviction in every case that's tried.
Judge, I'm going to object. This is an improper argument. May we approach?
No.
He's arguing that the government's role is simply to get convictions, that that's undisputed.
Judge, may I respond to that?
Improper closing
You
argument.
may.
I didn't jump out of my seat one time during this lengthy closing argument. I believe I have the right to defend my client and make remarks as long as they fall within the law, Judge.
Well, I agree with people on that. We praise.
Ladies and gentlemen, I'd like to start off not by recapping. I'm not going to go back to what I said in my opening statement about baking a cake, but actually it does come down to 4 items: elements, intent, credibility of who sat in that chair. And one thing I'd like to make absolutely clear, I think it is offensive and insulting to have a characterization of the typical domestic violence victim, that this is the way that they respond. That's insulting. You're telling me there's not plenty of men or women that are victims of domestic violence that don't get up that very minute, call a lawyer, start divorce proceedings? They always follow a certain pattern. We know that's not true. You can't say it's typical, because it's not. So I'm going to go through as succinctly as I possibly can each one of these elements and each one of these charges that have been leveled by the government against my client. Let's go to count 1. And I also should say this. We collectively are not blaming this victim in this case. I want you to understand that. What my job in this position at this time is to recap and make arguments on behalf of my client. So where do these arguments come from? What are they based on? They're not based on pie in the sky things that I think may have happened, or you may have happened, or the government thinks what happened. It's what was presented by individuals that sat in that chair. I know for a fact, I told you this, and I've said it each and every time that I've stood in front of a jury, is by the time you've gotten to this point, and you've just heard a voluminous amount of testimony, everyone gets tired, where they don't want to hear anymore. I told you in the beginning, very most important part. So whether you believe the government, whether you believe my client, whether you believe me, it's the testimony that was given in this chair. And I will get to that. But I want you to understand one thing. There's no way that I'm trying to convey to you, through my client or myself, that the complaining witness is at fault. I will certainly question her credibility as we go through her testimony on the stand. But that's the last thing I want to convey to your jury. I won't disrespect you like that. So, when you go through a trial like this, and I'm serious about this, when I looked over on occasion, most of the time, you know, I'm focused on the testimony, as you all were too. I've never seen a jury that's as attentive. You have notepads, and I continuously saw each and every one of you taking notes. That's important, because it's hard to kind of pull it all together when you go into deliberate. And we do appreciate that fact that you were attentive. But I'm sure in each and every one of your pads somewhere are probably a few questions highlighted. Maybe things that just simply don't make sense, good or bad. Where's the testimony given about this? So I like to begin with, I think, something that's extremely important, because really it touches just about every one of these elements, and it touches each and every one of these counts to a certain extent, and that's the weapon involved. Now, I'm not going to go into one of the bags, fish the gun out, parade it in front of the jury. Again, you saw the gun was presented on the stand. It's a heavy piece of steel. There's no contradiction to that. And quite frankly, I take very good notes as well. I don't recall the doctor testifying that there were significant head lacerations, as the victim claims that she was in effect pistol whipped or beaten severely with this gun on numerous occasions. If that was the case, if that truly was the case, why was there no testing done on this gun? Why was there no testimony given that there was blood on this gun? Why were there no fingerprints taken of this gun? We heard from, I believe, 3 evidence technicians, several police officers. And once the gun was admitted and shown to the jury, that's the last we heard about it. No fingerprints, no hair, no blood. It's like the gun was just put away and testimony was given. That's a big red flag and a big question to me. She was repeatedly beaten about the head. There was no medical testimony proffered by Dr. Taylor regarding post-concussion syndrome or a fractured skull. Now, we're not talking about, if you're not familiar with the firearm, we're not talking about a piece of plastic. We're not talking about a synthetic material. We're talking about steel. And if an individual is beaten about the head repeatedly, as was argued by the government and somewhat testified by the complaining witness herself, those injuries would have been very specific, especially when you're confining those injuries to the top of the head, which is what she testified to. No blood on the gun, no hair samples on the gun, no fingerprints. I specifically asked, I believe, every one of the evidence technicians that came up here, was the weapon involved ever dusted for fingerprints? The testimony was basically unanimous. No. Well, why not? Because one of the key questions that was asked and answered by the complaining witness herself was, if fingerprints were taken of this gun, would your fingerprints be on this gun? And her answer was, I don't know, I don't believe so. I said, did you make contact with this gun during the course of this struggle? She said, I either grabbed at his hand or I grabbed at the gun, or both. I don't remember. And coincidentally, again, just going by what was testified to, not only here, but a hearing that you weren't privy to, which is a preliminary exam, of which we cross-examined the complaining witness with that transcript. I don't know, I don't recall, was used so many times, I can't even keep track. I am refreshing testimony that was given, not something I'm making up. That's what she said in the chair. This gun is a significant part of your deliberation process because it goes through each and every one of these counts. It goes through each and every one of these elements. So I'm going to briefly go through these. Assault with intent to murder. Government has already discussed this. It all comes down to what we talked about in the beginning. The defendant's intent to kill the person. She's absolutely right. None of us were there. There's no videotape. There's no surveillance video that was lifted from any of the buildings that were few and far between. There's no cell phone videos. They're just two people in a field. So we have to draw inferences from circumstantial evidence as well as what was presented here. And the one thing I certainly will agree with, and this is sincere beyond what I can express, Madam Prosecutor said something that's very important. If you have a doubt in your head about which side to believe, which testimony to believe, don't believe myself, don't believe the government, go with what you believe, because that's your role here. All we can do is try to aid you into coming to a conclusion. We heard testimony from a number of people, but most telling, I would say, is the complaining witness herself. I asked her several times, the question's been asked, did my client ever threaten to kill you? Her answer to that question, each and every time she was asked, was no. He certainly had an ample opportunity, if that was his intention, to do it over the course of 17 hours or however many hours this actually took place. He did have a weapon. He's licensed to carry the weapon. He was attempting to reconstruct his life and get into the bonding business. Had a CPL. He had the Fugitive Recovery Badge. Had made connections, and I should also say, and I will get to this and elaborate on it a little bit more in just a bit, that my client didn't hide under that table, didn't turn his back. He sat there and told you what I believe was what happened. He apologized when he didn't feel he was able to communicate. He apologized to Madam Prosecutor if he felt that he wasn't answering the question properly. That was his concern. He wanted to say what he's been trying to say all along. And if there's ever been a case of overzealous prosecution, it's this case. And as we go through it, you'll see. Intent. So honestly, if we sit here 4 days later, if his intent was to do as is alleged by the government, but somehow he was stopped in that, someone stumbled upon him and prevented him from doing it, he had certainly ample opportunity to do that if it was his intent. His testimony was he wanted to kill himself. And how did he demonstrate that? By his own admission, he took a handful of Vicodin, 15 to 17 pills. He held the gun to his head. Which brings me to another point. 3 evidence technicians and countless police officers testified, sat right in that chair. My question was simple. They picked up and took pictures of cookie bags, chip wrappers, all kinds of other items. Those were all marked. The gun was shot one time. Where's the shell casing in this case? Where is it? In fact, I asked specifically one of the evidence technicians Did you get down on the ground with a flashlight, look under the seats? I thought her testimony was very credible, and their answers were all the same. Couldn't find it. We don't know. Found cookie bags, found potato chip bags, found whatever else they found. But key crucial elements of evidence are simply not there. There's a gun with no prints, no blood, no hair, but he beat me about the head several times. I will concede this right now. Of all these counts, aggravated assault is what happened that evening. No man should ever do that to a woman. He's the first one that admitted that, how he felt about that, the shame that he felt, the guilt that he felt. He realizes that. That's what happened in this case. He beat her. He beat her. If you really look at the elements of this offense, you will see that this is the proper decision to be made in this case. Aggravated domestic violence. They lived together, they had a child in common, and he punched her about the face numerous times, broke her jaw. That's undisputed, and you know what? It's not typically in my nature to say, hey, we'll concede one of these charges. But I told you the first day that the last thing I'm going to do is treat a group of individuals who we handpicked, both Madam Prosecutor and myself, for your intelligence based on the questions that the judge asked you, based on the questions that we asked you. I'm just simply not going to do that. I'm going to let the testimony and we only have 2 exhibits. One is the statement about, that's Exhibit A. You'll be able to read that and go through it. That was pressured by my client. Basically, he forced her to do everything, including this, that was filled out by her own testimony in the doctor's office to please my client. She didn't want to get in any more trouble. Now, frankly, this is a woman that the impression I got was very independent, strong-willed, significantly educated, and had achieved a lot in her life. So my client, as a construction worker who came to this country, as he said, with $100 in his pocket, doesn't have that educational background. He testified to that as well. So sitting inside, you know what? I hate doing this. I really hate writing down things and then spouting them off. Because I sat there, just like you did, paid attention, and can tell you what our position is in terms of what is right. And I wrote this down, that obviously this is a fractured, dysfunctional relationship and marriage that was fueled by all the worst possible things: mental illness, drug abuse, feelings of failure. On both parts, we heard that. We were sitting in the same courtroom, we heard that testimony. And I just find it unfathomable that someone can say every part of that marriage, whether it be treating with several mental health practitioners, dealing with their child, dealing with family and relatives, every single negative thing that happened was based on trying to keep this man happy, who allegedly beat her, even though she wrote out a statement that said she never did. The therapist said, well, I've never seen that. Well, it's addressed to her. Did he lose his temper at the therapist's office? Absolutely. Absolutely he did. He told you why. He felt he was being picked on and he wasn't being listened to. You're telling me that you or somebody you know has never stormed off in a situation like that? She made him go wait out in the waiting room. He had enough of that and he left. But apparently that's a huge component of this case. It's meant to confuse you. It's meant to say he did this, he did that. But what it all comes down to are the elements of these offenses. The intent portion of this goes through each and every one of these elements. What was his intent? And I've said this, it was repeated by me and a prosecutor. Of course we can't get into somebody's head. We can only go by what was testified to and what was presented as evidence. This Exhibit B, you're going to have the opportunity, each and every one of you, to go through this 6 to 7 page document, which is in complaining witness's handwriting, which is signed in 3 different locations, and what will you see? You'll see on the this is an intake form, by the way, from the, well, it says Bloomfield DBT, but I believe that was what she referred to as the Rochester Center for Behavioral Medicine. Basically, it's like every one of you have encountered, you go to the doctor, why are you here today? Well, we need to get a medical history from you. And that's what this is. And this is what you'll see. This is what you'll be able to review. So let's go. This is very brief, by the way. Symptoms currently: lying, deceiving, manipulating. Her handwriting, her signature. Next page. I asked her specifically, I believe a prosecutor asked her the same thing, regarding thoughts of suicide, suicidal manifestations in your mind. No, I don't have that. This is dated 3/21, by the way. Problems you are experiencing currently. There's a box to check, currently or in the past. Thoughts of suicide. The box is checked. Currently. 3/21. And the prosecutor also discussed with you that Mr. Muntean wanted to control Mrs. Muntean's family. This is, I believe it's page 5. I should also indicate it asks her just to show credibility. I believe it was 3 times in here. How long have you been married? 12 years. Divorced? In the process. I know specifically, I asked her, are you still married? Yes. Have you started any divorce proceedings? No. Has there any court documents been filed for divorce? No. Are you legally separated? No. But yet it appears here. Concerns between you and your loved one cannot be open and honest. I think I'm superior and manipulating. I don't feel empathy or regret for my actions. Always think only of myself. Lying, deceiving. Concerns between you and your children. I don't love her. I don't want the responsibility anymore. And she gets into her family. I'm sorry that I kind of got off the track there, but the prosecutor indicated his intent was to manipulate her, keep her from her family, control her, I believe was the word used. Father. She describes strong, alcoholic, reliable. Mother. Dependent, overprotective, and manipulative. These are the people that allegedly Mr. Muntean was trying to control through his daughter. And you'll be able to go through all this at your own pace. Intent to murder? Absolutely not. I told myself I wasn't going to use any analogies, but I have to use one right now, because it was brought up several times, of the baseball player that's standing at the plate. His intention is to go up there and hit the ball. He wants to do that, but he swings and misses. His intention was still there, but he swung and missed. Okay, well, simple as that sounds, if you believe the testimony or the arguments made by the government, he had 17 hours to swing and miss. But what did he actually do? This is just not his testimony. It's testimony by the complaining witness herself. He attempted to render aid, attempted to dress the wounds, cut off the pant leg, and then he freaked out. He didn't know what to do. He gobbled a whole handful of Vicodin. He didn't know if he was going to kill himself at that point. Phone calls were made. In terms of unlawful imprisonment, the one thing that was left out, that I should tell you, it's crucial in making your determination, is this. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret. Is that what was testified to? My client called Alex. Complaining witness texted, called Alex. Complaining witness knew Alex was there. She heard her. She testified, she looked over the back seat, saw her. No screams. I got a phone, 911, please help me. That's all you have to put into a phone. You know that. If you're in your cell phone, you don't have to be in your house phone. You could be in your car anyway, or get in an accident, something happens in someone else's home, 911, they'll find you. They'll find you. That didn't happen. Again, not affixing blame here. What I'm saying is what was testified to. So it wasn't a secret location. In fact, he walked away once his mind cleared and he realized he couldn't get out of that field with his wife. There's no gas in the car. He can't get it started. Walked down the street, saw one individual. That person didn't want to get involved. Hey, at that point, I don't blame him. It's dark. Some stranger comes out of the field. And I'm not stopping. I don't think any of you would stop either. So at this point, he doesn't know what to do. He knows he made a big mistake. Should never have laid his hands on his wife the way he did. He told you that. He told you that. It's not like he said, I never touched her. I didn't do any of that. He told you that. Second individual he encounters, which is very telling, is the officer that first appeared on the scene sort of by happenstance. He's investigating stolen cars, as is his job. He's undercover. Now, I want you to understand that. He is not in a policeman's uniform. He's not wearing a badge. He testified he was undercover. He just happened to be in that area. Gets out of his vehicle because he notices another vehicle parked back in the weeds, which was conducive to where people dump cars when they steal them. That's why he was there. He told you that. He also told you this. My client approached him. He didn't jump under the truck to try to hide. He didn't run away. He approached him. And based on his last encounter with the other gentleman, what did he do? He had the badge. He told whoever that was, he walked out. What did he ask for? He said, "Can I get some gas? I ran out of gas." Rational thinking? Probably not. But what did he do? I'm not talking about what he said he did. We'll get to that in a little bit. I'm telling you what the officer said. And police officers, they've been through this, they testify. He told you what was in his report, what he said, what he saw. And and much to the prosecutor's credit, hopefully myself as well, we didn't interrupt this trial. We didn't jump up and down and say, "I object, that's this, that's that," which, if you've ever, and the majority of you have testified, or not testified, but have told us that you've been in jury trials before. And sometimes it's just an unfortunate tactic to throw the other side off when they're gaining momentum. Or it's a violation of the rules of evidence. That officer testified that my client approached him. So if his intention was to secretly stash her away, or it was to kill her, would he have run towards the officer or that individual? Even after, and the officer, I believe, testified to, there was still some distance between them, where the officer was able to ask him questions. He made no effort to flee, to run. He stayed right there. He knew he had made some significant mistakes. But they do not rise to the level, and I have to keep not only reminding myself, but reminding you as well. If we're dealing with intent, it's nowhere close to being shown that he had the intent to murder her or to kill her. You know, the DNA evidence, and I respect science. I think it's a crucial component. You know what I got out of that information? And I know a thing about DNA as well as Madam Prosecutor. Was the second gentleman that testified. He was the manager of the lab facility. And his conclusion with the quadrillion, it was a certainty. That's basically what he was saying, but they can't say it's 100% foolproof, but that number with 24 zeros after it is good enough for me. What did he say? After all that testing of blood, what they found was this. They found a blood sample with her DNA from the complaining witness, as well as what more than likely was a DNA of some sort from my client. So what does that mean? Where was it found? The clothes have been displayed. Numerous pictures have been displayed of the interior of that truck. But what was analyzed and what was found? Blood sample on the outside of the truck. On the outside of the truck. The government would lead you to believe that she was imprisoned inside this vehicle against her will, bleeding out, hypothermic. I'm not saying she didn't suffer injuries. Of course she did. We're not contesting that. Just not the intent to kill her or to cause great bodily harm. The thumbprint on the outside passenger door, the blood sample, the DNA, proves, by whatever number that was with 24 zeros after it, that she was outside this vehicle at least once, but more than once. You know why? Because the government's it brings up continuously this blood trail. And I know I asked at least 2 or 3 different individuals, including the evidence technician, what a blood trail is, what's necessary for a blood trail. basically droplets of blood. How far did that go from the truck? Different estimates. The conservative estimate was 10 feet. That was by Alex, defense witness. And what we, I guess, basically agreed was from here to there. So she had the ability on at least one occasion to step out of the truck. And then she had an ability to walk. Again, I hate to be crass, but it's part of the evidence that she was injured in the leg during the struggle in the car. Secondly, she was on her menstrual cycle. And the tampon was found outside the vehicle. Again, not to be too crass, but there was a trail that led from the car to approximately 30-ish feet away. So I'm not saying there's ample time for her to escape or whatever. What I'm saying is this. If his intention was to murder her or continue to beat her and mentally destroy her over the course of the 17 hours, he sure as heck had the opportunity and would not let her go wandering off on numerous occasions. He wouldn't, this doesn't make sense. He wouldn't leave her with a phone where he testifies, she testifies, she's texting, she's calling. These aren't things that I'm trying to convince you of. These are things that were testified to. It's a matter of record. So Alex shows up at the field. I don't know. She knew that Mrs. Muntean was in that truck. She spoke to her on the phone. They had a conversation regarding jewelry. Is suicide an element of this case? I think so. I think so. Because I think when people that have underlying grave mental illness, perhaps on both sides, you mix that with the flammable combination of disintegrating marriage, when you were raised to stay married and protect your child and raise your child together no matter what, and the next thing you know, all that's falling apart, that's what ends up happening. But the intent to murder, intent to do great bodily harm, unlawful imprisonment, and torture. I wanted to get to this. If you strictly go by what the elements of the offense are, which is your duty as a jury to do, one of the elements is threatening the person with imminent death, or threatening another person that you're going to kill them. It's not coming from my client's mouth. It's coming from the complaining witness's mouth that said, he never said he was going to kill me. That's one of the elements of this offense. And, by the way, if everyone that was a victim of an offense, who was shot or had a broken bone or was significantly beaten up, if that's torture, these hallways would be filled with individuals that are being charged with this offense. It simply does not raise itself up to that level where he tortured her. There hasn't been testimony that substantiates this. There wasn't. Basically, there was a huge blow up in the truck, as he testified to. It wasn't directly argued, but I believe it was implied that he had all this planned out. He knew right where he was going. He just happened to know where Linford and the other street, and he knew where this field was. The guy, he had testified himself that he had taken so many pills, as well as the complaining witness had also testified to, that he was definitely nowhere near the right state of mind. But I can tell you this, given the circumstances that they found themselves in, the opportunity was certainly there. The time would certainly have permitted that to happen. But the intent is just simply not there. This isn't torture. This is a disgusting, despicable, aggravated domestic violence situation. And I told you right in the beginning, that's the only thing that got me a little heated. I always try to keep my composure, but you can't describe what a typical domestic violence relationship is, because it runs the gamut. There's some people that, even if they're threatened by that, they're gone, or they're calling the police. Okay, this is not Ozzie and Harriet. This is not a healthy relationship by any means, and no one testified to that it was. Even my client who took the stand, which is what I want to kind of get to in summing this all up. The word that he used most was defeated. I felt defeated. It's a shame, it's a crying shame that he didn't seek out mental health treatment, as did the complaining witness. Would that have helped? I don't know. I'm not, definitely one thing I'm not as a therapist. But I know this, it certainly couldn't have hurt. And maybe the situation would have been avoided. It's undisputed testimony given by complaining witness as well as my client that the gun was fired in the truck. And he made a demonstration of that by that, and is perfectly plausible. Alex had said that these two had been at each other for the last 2 weeks leading up to this event, culminating in this event that was fueled by drugs, anger, rage, mistrust, driving down the road. And I believe that came from the witness chair on 2 occasions. I'm going to go before you. Takes the gun, puts it to his head. He knew how to use a gun. I asked these questions. There is a safety on that weapon. There is a safety. Safety's off. His hand's here. I asked the complaining witness specifically, if that gun was tested for fingerprints, would your fingerprints be on the gun? I've already told you what the response was. There was a struggle. There was a struggle inside that cab. So, if you got one hand on the wheel, one hand with a gun to your head, someone who reaches over and grabs for whatever reason, because I firmly believe she didn't want him to kill himself either. Gun's pushed down, weapon is discharged. He didn't take her to the field and then finish the job, so to speak. He didn't. He didn't do that. It wasn't his intention to do that. And a lot can be said for this. I know the judge got into this earlier. It's his obligation to do it. And the prosecutor has stated it. I've stated it as well. My client's under no obligation to do anything but appear. He can sit in that chair. And I don't think I used it. If I did, I apologize, because I hate using analogies. But if we decided to sit through this whole trial and just play cards the whole time, not offer any testimony, I don't question anyone, just sit there. That's his right. He's presumed innocent. I don't care how many pictures you put on that screen, he is presumed innocent of these offenses. It's a horrendous example of overcharging an individual, not minimizing what happened. I'm not saying these injuries are not significant. Of course they are. The gunshot happened during a struggle. Wasn't his intention to shoot her or kill her. In fact, he had the gun to his own head. Gobbled down a whole handful of pills. I don't know how that didn't kill him, but I'm not a toxicologist or a doctor. You know, at this point, I'm sure that you just want to have a moment with each other. And I believe the judge indicated this to you, and I think it's true. You know, most juries, when they go through it, or most individuals, let's take it out of a jury realm, but if you are together under stressful circumstances, for the most part, one of two things happen. Sometimes you're at each other's throat. There's chasms that form. You know, one group's over here, the other group doesn't like that group, and whatever. But secondly, which I think happens most often, is that there's a bond that forms. You know, whether that's like, I don't like the government's way they're proceeding. I sure as heck don't like that defense attorney. I can't stand, you know, the ties he wears or whatever. But when it comes right down to it and you're making a decision, this is what's important, is the elements of these offenses, and they're really broken down, I don't want to say strictly in layman's terms, but they are. They're understandable. That's what you have to look at. What was said in this chair, not just by the complaining witness, not just by my client, not by Alex, but by police officers, by physicians, by DNA experts. Put that all together. See which one of these offenses fit those facts and fit that testimony that was given in that stand, or on the stand. And I'll tell you right now, this is after discussion with my client, I will certainly concede that. This is a heinous, aggravated form of domestic violence that went way too far. But being that it went way too far does not mean he should be convicted of these offenses where those elements were not met and not testified to. And I thank you for your kind attention.
Rebuttal.
Thank you, Judge. I'm glad that the defense attorney talked a lot and argued a lot about what the elements are, except that when he was telling you about what the elements are, he didn't actually discuss any of the actual elements that we have already gone through. Let's talk both in counts 3 and 7 what the elements actually are. He mentioned that one of the elements of unlawful imprisonment is that the person was secretly confined. That's actually an and/or. So the second element of unlawful imprisonment is that, second, the defendant did so under one or more of the following circumstances. 1, the person is restrained by means of a weapon or dangerous instrument. 2, and/or, the person was secretly confined, which means to keep the confinement or location of the restrained person a secret. And/or 3, the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of that felony. So if you believe that Alex's presence there in that field takes away that secretly confined, there's still 2 other and/ors, the restraint by means of dangerous weapon or restrained to commit another crime, another felony. So that's what the elements are of unlawful imprisonment. For torture, what the defense attorney was arguing was that one of the elements is a threat to kill. That's another situation where it's an and/or. So it's that the third element rather is that the defendant had custody or physical control over the complainant, and that he intentionally caused great bodily injury and/or severe mental pain and suffering. And what you'll see is that the elements describe for you what great bodily injury is and what mental pain or suffering is. And you have a choice. And if you believe that any one of those things happened, so that if you believe that the defendant intentionally caused Ms. Muntean great bodily injury, which can include serious visible disfigurement, a skull or serious bone fracture, subdural bleeding or bruising, and then any one of the list of things that can be done to cause somebody mental pain or suffering, that's enough. It's not just that he threatened to kill her or that he didn't threaten to kill her. There are additional elements there, additional things that can be shown to meet that element and meet that burden on that count. What the defense is arguing is essentially your job as a juror is to have a spotlight on the elements of the crime, to look at the elements, look at the evidence like we went through in my closing originally, and see if that evidence that you've heard, that you've seen, proves each of those elements beyond a reasonable doubt. What the argument is that they are trying to argue is basically attempting to take the spotlight away from those elements and point it somewhere else. Point it on Natalia and her mental health issues. Point it anywhere that's not the elements, because the reality is that the evidence in this case has overwhelmingly proven each of those elements of each of those charges. He said that it's offensive to characterize someone as a typical DV victim. Yet we all know your job as a jury is to use your common sense. Your common sense. We all know that there are such things as domestic violence victims. And you have the testimony of Judy Redmond, who said that Natalia was displaying symptoms of battered woman syndrome. So we know that. We know, based on the defendant's own admission, that she was a victim of domestic violence, and she's acting in conformity with that. The intake papers that he was displaying, I think it's Defense Exhibit A or B, from DBT, Natalia explained to you, first of all, that she did not fill that out in the doctor's office. She filled that out at home. Second of all, she explained to you that that was not from the Rochester Behavioral Center where Dr. Redmond works, or where Ms. Redmond works, that was for another program that she was applying to, and it was supposed to be for a release of those records. She was applying to this program. She explained to you why she checked that box, that she was having suicidal thoughts. She said that she's had suicidal thoughts in the past, and she's trying to be honest and disclose everything that happened, and so that's why she checked that box. But let's get to this topic of suicide. At the end of the day, so what if she was suicidal? So what? That doesn't obviate, mitigate, or take away his intent that she not leave that field alive. At all. Because the evidence has shown that that's exactly what his intent was. I submit the evidence has shown that she was not suicidal. She told you she was not. But whether or not she was suicidal doesn't mean that he didn't intend to kill her. And that's exactly what he attempted to do, and that's exactly what the evidence has shown. Why wasn't the gun fingerprinted or anything? The gun was taken off of the defendant. He admitted to having the gun in his hand in the car. He admitted to the gun going off while it was in his hand. We know where the bullet is. The bullet ended up in Natalia's right leg, and we know where it is now. It's over there in one of the evidence envelopes because she had it taken out. He admitted that the gun went off in his hand. She tells you that he pointed it, aimed, and shot at her. So what if there's a shell casing that's not found? He had ample opportunity to throw it out of the window while they were driving southbound on 75 if he wanted to, or it could have gotten lost in the field. The point is that we know that that gun shot her in the leg. He tells you that it did. We have the bullet. A lack of shell casing doesn't mean that the elements of those crimes that we went over, the evidence hasn't proven those elements. Natalia, as far as whether Natalia's fingerprints were on the gun, yeah, she said that she tried to push the gun away from her when he pointed it and aimed it at her, before he pointed it at her again and shot her. And if the defendant's story that they're both sitting in this truck, if that's to be believed, ask yourself about the angle of that bullet, how the angle of that bullet would have gone into her leg. If she was pulling the gun down, wouldn't that have been in downward angle? Look at the pictures of the gunshot wound and ask yourself, what's more consistent? If this was aimed and went straight through her leg, her left leg, People's Exhibit 15 and 16. Her right leg, 17 and 18. Looks like a clear straight through shot. not consistent with the defendant's testimony. Again, defense counsel harped on the never threatened to kill her. You have Natalia's testimony that she's in the field after he makes a comment about who's going first. All she's thinking is, what's he going to do? Is he going to shoot me in my chest? Is he going to shoot me in my head? What's that feel like? Is that going to hurt? That's torturous. That is inflicting mental pain or suffering, making somebody wonder how their life is going to be ended by that gunshot. If it's going to happen, where it's going to happen, how it's going to feel. The defense attorney argued about saying something about the elements not being there and then referencing the no prints on the gun. Whether or not there are prints on the gun is not an element of the offense. You know what the elements are. You've heard about them ad nauseum now, and you're going to hear about them again when the judge reads them to you. That's not an element. He said aggravated assault is what happened. The way that Natalia looked, remember, she would only let 3 photos be taken of her at the time. And I want to talk about her statement to the police afterwards. People's Exhibit 10, how Natalia looked at the time. This is more than aggravated assault. And this is not, her face is not the extent of her injuries. You know that she has that jaw fracture. And how do we know that she has those lacerations on her head aside from what she testified to? Because they're talked about in the medical records, which are in evidence. So you can look at those. We know that she had lacerations on her head that had to be stapled. It's in the medical records. And how would it be possible, ask yourselves if it would be possible, for the defendant to break her jaw, to break a jawbone by haphazardly punching her a few times in the car? Or ask yourself, is it more consistent with someone being beat about the head and face with the butt of a gun? And again, the fact that there was no blood or no hair found on the gun. There was hair found out in the field. The same field where Natalia said the defendant pinned her to the ground and was beating her about the head. And again, he had blood on his jeans, blood on his jacket. He had ample time to wipe the blood off the gun, if he wanted to. Just because there's not blood on the gun doesn't mean it didn't happen. We know it happened. We know because the medical records, we know because Natalia tells us it happened. Let's talk about the therapist's office. You're telling me that that therapist physically pushed the defendant? You had the opportunity to observe her demeanor, observe her testimony, and you can judge her credibility. And ask yourself who you believe more. If the defendant began calling her aggressive after she found out that he in fact had beaten his wife, or if she really pushed him. The defense attorney argued a lot about the defendant. What did the defendant do? He rendered aid. He rendered aid by giving her some antiseptic spray after he shot her in the legs and then stabbed her and then beat her, strangled her, so on and so forth. Was that really giving aid? He also said that it was at that point that he gobbled the Vicodin. But no, we know that that's not true because the defendant testified that he took the Vicodin allegedly before he went into the field. He mentioned the argument was that Natalia had a phone all night. I'm not going to readdress. We already talked about Detective Markle's testimony, and that she could have called somebody. So my understanding of their argument is that it was Natalia's duty to end the brutal assault that was happening, that the defendant perpetrated on her, that it was her duty to call 911, to call somebody for help. But we know that she was afraid of him. She knew that he had a gun. She knew that she's been brutalized, and she told you that she couldn't walk. She tried to get out of the car, and that's why this whole argument about there's blood on the outside of the truck. She told you that she tried to get out and walk, and she couldn't. So, yes, is there blood on the outside of the truck? Yeah. Is it her blood on the outside of the truck? Yeah. Why is her blood on the outside of the truck? Because the defendant inflicted such severe injuries repeatedly that she was bleeding profusely. You also have the testimony of Sarah Shuba, who, interestingly, I think I forgot to mention, said that she wasn't able to get any wrist or foot pulses detect a pulse from Natalia when she saw her because her body was so cold. And she didn't think she was actively bleeding at that point anymore because her body was so cold. And I'm not going to dignify with much of a response the argument that that blood trail in the field could have been from Natalia's menstrual cycle. I think using your common sense and your personal experience, you know that that's outlandish. There was no testimony that Natalia wandered off at any point. She couldn't wander off because the defendant had incapacitated her. She tried to get out of the car once. She got out again at some point when the defendant started beating her again. The defense attorney said suicide, he believes, is an element. Suicide is not an element of this offense, of these offenses. You know what the elements are. We've talked about them. He's also minimizing her injuries, which I'm not going to go over again. But please look at the medical records, and let's talk about the medical records, and let's talk about Natalia's statement to the police afterward. She told you that she told the police what happened, and then she said she didn't want to press charges. This was the same day that she was found, and she said it was all a misunderstanding. If the defendant's version of the story was true, and we know that Natalia didn't want to press charges at the time, we know that she wanted to protect him, why wouldn't she have just told them the same version of the story that he gave you? Why wouldn't she have just said that it was all an accident? The story doesn't make sense. Natalia's testimony is corroborated by the physical evidence that we have in this case. It's corroborated by the physical evidence, and it's corroborated by the testimony of the other witnesses that you've heard. The statement that the defendant made about someone going first, the defense attorney characterized that and argued that that came right after, or right before, the defendant pointed the gun to his own head. That's not true. We know that from Natalia that that statement came much later when they were already in the field. Yes, the defendant is presumed innocent. He's presumed innocent until the evidence has been introduced, until you go back there and you look at the evidence, and the evidence strips away that presumption. It strips away one piece at a time until the evidence proves beyond a reasonable doubt that he is guilty. That's exactly what's happened in this case. There is ample evidence that he is guilty of each of these offenses. And again, Natalia is not on trial. She's not on trial for staying with him. She's not on trial for not calling 911. She didn't have a duty to end the brutal assault on her. Remember that my burden is beyond a reasonable doubt, not beyond any and all doubt. We talked about this in the beginning, that there's nothing that we can prove, that anybody can prove with 100% certainty. But a reasonable doubt is a doubt that arises out of the evidence or lack of evidence. And I think you've seen and heard in this case that there is ample evidence, and the evidence is proven beyond a reasonable doubt the defendant intended to kill Natalia, and on the way to achieving that intention, that he tortured her, he assaulted her, so on. If you go back there and you think, if you sit down and you think, he did this, that's it. I've met my burden. If you go back there and you think that he did this, I have met my burden. Don't go picking things out of nowhere. It's beyond a reasonable doubt, and if you go back and you think he did this, I've met my burden. If the defendant really loved his daughter, as he told us yesterday, and he glowed when talking about her, why would he come up with this plan to kill himself? And he certainly wouldn't want to be away from his daughter and take himself away from his daughter. His story was wholly incredible. Because the elements in this case have shown beyond a reasonable doubt that the defendant committed each of those offenses. Again, I ask you to find him guilty. Thank you.
Short recess, please study picture. All right. may be seated. Please approach the bench.